Masterson versus Masterson. Hang on one second, Mr. Kirschner.
Yes, sir.
All right, whenever you're ready, sir.
Good morning, Eric Herschel on behalf of Mr. Masterson. And what we have here is an alimony case, rehabilitative alimony, where the circuit court awarded $2,500 a month as rehabilitative alimony for 24 months, and then retroactive alimony, $2,500 a month for 18 months, predating the judgment absolute divorce. Now, the court found that Ms. Masterson could work, and she could earn a job making $45,000 to $65,000 a year at the time of the judgment. Now, Maryland, the principal purpose of alimony is to rehabilitate. So the court must consider the time it deems necessary in making its decision in alimony. It must determine the time the court considers necessary for the party seeking alimony to gain sufficient education or training to enable the party to find suitable employment. And the court's own finding was that she was already there, and there was no...
Well, she had been there when she was working for his business.
That's right.
But as they're divorcing, she's not going to continue to work for his business. And I thought the court found that it was going to take her some time to get trained, find new work that wasn't in her now ex-husband's business.
Well, she hadn't been in the business for some time at the time of the divorce.
Right, and she was making a whole lot less in the time after she left his business than she was when she was working in his business.
Because
right?
she made no effort to find full-time employment.
Well, that's the argument, but that's not what the court found.
Well, that's what the testimony was, that she didn't. And even if the court found that she needed time, the court doesn't tell us why she needed time or how much.
This is what I'm struggling with. You've got transcripts with a hearing in this case, and then you have a detailed written opinion by Judge Dumais. Both of those things. I'm struggling to understand your no explanation theory, which runs throughout all the issues in this case. The court took testimony, took evidence, made findings, explained its reasonings, showed its work. How can you argue that there was no explanation here for what the court did? Because
in the findings, there's no explanation as to what is she going to do for this 20 months period that's going to rehabilitate her.
I thought she was getting a real estate license, so she would need to spend more time doing that and then build up her business. I mean, there was testimony, right?
Right.
Well, the testimony was that she needed to take a 60 hours course in order to qualify. And then once she passed that 60 hours, she had a position with a friend of her father's down in Mineral, Virginia, where she could start working as soon as she had the license.
She could if she moved there, which she didn't want to do. But in any event, she was working, she was getting this real estate license. You can't just snap your fingers and have an income selling real estate. That takes time.
That's right.
And the court recognized that.
Yeah, but the court doesn't tell us why 24 months. There was no evidence that it would take 24 months. It's just a number pulled out of the air.
So she could have done longer.
But she's got to say why. She's got to say, why 24 months? Why not 18 months? Why not 20 months? Why not 36 months?
What case says she has to say why she picked a certain amount of time?
Well, let me just find it here real quick. Because the...
I mean, doesn't it just have to be supported by the record?
There has to be a clear line. Is it long? Let me just... Because the chancellor failed to draw a solid line between the facts and the remedy, explaining fully how the former justifies the latter, he abused his discretion in our view. That's Long versus Long, 129 Maryland Act 554. So I think the law is that they have the circuit court has a lot of power to award alimony, but in exercising that power, it's got to explain why it's doing it and justify why it's doing it. Because extreme amount of power the court has in awarding alimony. And as a break on that, or as a control on that, they have to explain it.
It is clear from the facts of this case that plaintiff requires financial assistance for a period to begin living her separate life, and defendant has the means to provide such support to plaintiff.
That's a conclusion. What are the facts supporting that conclusion?
Well, it's grounded in which the court previously makes a finding about the sufficiency of husband's income. The court walks through all the factors, and again, you have this written opinion, but you also have the findings the court made on the record. I mean, are you saying there needs to be like a precise calculation? She has this much income now, he has this much income now. We project that she will make, her income will grow by X% a month, and so therefore she will, after 12 and a half months, she will reach a sufficient level of income and alimony can stop then. And without that sort of mathematical precision, alimony can't be awarded? Is that your argument?
No. My argument is that the court has to say what training or what education or what reason, other than just conclusions that, well, he can pay it, she needs it, so that's sufficient. And that's what's not sufficient. There has to be some rationale as to why or the court thinks, in this case, 24 months at $2,500 was necessary. Otherwise, it's just whatever the judge thinks. But the law requires an explanation as to the remedy. Why is this court ordering $2,500 for 24 months? Why are they doing that? And why didn't the court also take into account, in making that alimony award, the prior alimony award? There's no reference as to how the one affected the other. Because once the alimony was awarded, the back alimony, that gives her Ms. Masterson's $34,000 at that point, which is going to be paid out of the proceeds of the sale of the house. Now, the court doesn't address that factor at all, or how that affects anything. And also in this case is the court says that the factor of what training she needs and what education, what she needs to do in order to get back on her feet, the court says that factor is more or less irrelevant in this case. So the whole point of the alimony...
Wait, I don't understand what you mean by that. Where did the court say that her education or efforts to become self-supporting are irrelevant? I thought you were saying that the court didn't explain in enough detail why it got to 24 months, but I don't remember the court saying anywhere that her education or efforts to become self-sufficient were irrelevant.
The court found that the factor was not relevant to the case.
Which factor?
About her rehabilitation. Now, let me just find it. I know I put it in the brief.
The time necessary for the party seeking alimony to gain. Okay, that factor is not particularly relevant.
Particularly relevant.
Court notes that a husband can cover the housing needs monthly. Wife cannot at this time without assistance. For wife to get settled in her new single life, she'll need alimony for a defined period. She's clearly capable of working as an executive assistant and should be able to earn between $45,000 and $60,000 based on her testimony.
That's right.
So the court maybe didn't find it particularly relevant, but considered it and then made findings about their relative income, her relative ability to cover her expenses, her ultimate ability to get paid, and that there was going to be time to do it. You're quibbling with the specificity of the findings, right? You're saying that there's not enough explanation here about how this court got exactly to 24 months, got exactly to $2,500, got exactly to its conclusion.
Well, there's no explanation as to how it got to that, other than these just general conclusions. And I think the law requires the court to do more than just have general conclusions. Otherwise, there's no check at all on the circuit court. You can't, another court can't look at what the circuit court did and say, yes, I agree, or I disagree with that. There's either facts to support it or they're not facts to support it. Now, that's part of what is supposed to be available, is have a meaningful review of that decision. And if all the circuit court needs to do is just say, I believe 24 months is sufficient, then there's no way to review it. The court basically, the circuit court would have unlimited discretion to award whatever amount that it wants for whatever term that it wants. And I think that's why the Long case says they have to draw a clear line between the facts and the remedy. And without that, it's just an arbitrary decision by the circuit court, unreviewable by an appellate court. And I don't think that can be the law. There has to be some check on the circuit court so that another court can look at it and say, yes, we agree, or no, we disagree. But there has to be that.
Well, we're not reviewing it to agree or disagree, right? We're reviewing the fact findings for clear error, and we're reviewing the ultimate decision for abuse of discretion.
That's right. And
So
how?
it's not whether, maybe each of us would have awarded a different number, maybe we would have put a different time on it. But isn't the issue whether the outcome is supported by the record?
Whether the chancellor's findings, the circuit court judge, I guess we used to call it chancellor.
Effectively, the court's sitting in equity, even if we don't have the distinction anymore, right? These are equitable. It's literally the equitable distribution of the parties' assets as they divorce.
So if the record showed that was just grossly outside what the evidence was, the court's ruling, then we would find an abuse of discretion. But if the record supports it.
But you can only determine if it's an abuse of discretion if you understand the reasoning that went into the decision. And that we don't have. We just have the conclusion. We have the result, but we don't have the reasoning that supported that decision. And that's what the court can review. You can, if there's...
the court said, she can get a job, but she doesn't have one right now, and she needs some time to get there and to pay her bills. So if that's all supported by the record, why, I guess back to Judge Zarian's initial question, you seem to want some sort of mathematical calculation, which I haven't seen in other cases.
No, that's not what I'm saying is that the court picked 24 months. Why did the court pick 24 months when the court found that she was already capable of working? She didn't need any education. She didn't need any training. She was qualified at that moment to work 65, to get a job making between 45 and 65. So why would those facts, did she then say, or the court then say, it's 24 months is what we need? There's no justification, no explanation for that. And that's really the problem, is what is the explanation? Why 24 months? Why not some other number? If Ms. Masterson's already able to work to the day of the judgment, making 45 to 65, what is the 24 months for? And we also have the back alimony, which isn't addressed at all, which also should have been addressed, is what is the justification for the back alimony?
The justification for the back alimony was that it reverts to the time of the complaint.
It's a discretionary award the court can make.
And the circumstances at the end of the divorce, at the end of the proceeding, were the same as the circumstances at the time of filing. What's the distinction you're trying to draw? If alimony and there's no child support in this case, but if those kinds of requests can revert back to the time of filing, and the court did that here, what is it you're saying is, other than your point about the detail and the explanation about why 24 months, it's 24 months running from the time of the initial complaint, right?
No, it was 18.
It's the complaint till now plus 24.
It was 18 months. It works out to April to November
right.
and then 24 months, so I said 18, like 36
30,
months.
whatever.
Somewhere around 36
Okay,
months.
but it can revert back, right?
Yeah, the court, I don't
Court
dispute
has
the court had
authority
the
to do
authority
that,
to do
and the
it.
circumstances are all the same. What distinction are you trying to make
What,
between the prospective alimony and the retrospective alimony?
well, number one, that the court should have addressed the award of,
It did address it, it granted it.
it should have addressed it in the sense that that gives her an asset of approximately $34,000 and a liability to him of $34,000 at that moment. Now, the factors are the financial conditions of the parties. For the alimony award, that's not addressed as the factors. But even so, there's no explanation as to the justification for the prior award of alimony other than just the raw power of the court to do it. And that's our complaint here is that it's just not an exercise of the power of the court to do this. The court has to explain why it's doing what it's doing. It just can't, yes, it has the power. I don't dispute it has the power to do everything it did. It's just that it doesn't explain it.
Okay.
And that it has to do.
All right, Mr. Kirchman, if you keep going at this point, you'll be eating into your rebuttal.
Okay. Thank you, Your Honor.
Thanks. All right, Mr. Ruben?
Thank you. I think I'll be brief.
Lawyers always promise this, and then.
Correct. Counsel at the end said the court didn't explain properly, and I think Your Honor was thinking initially, as I was thinking initially, that couldn't be. The answer, it had to be more of the factual decisions, or, the record didn't support the factual decisions. It was so far out, there was abuse of discretion. So to the extent that counsel was arguing that the trial court did not explain properly, don't rarely see it better than this, right?
Well,
I mean,
sometimes you see a lot more detail. I mean, it depends. I mean, there's a range, right?
There's a range.
And the question you always have is, how much do you want the appellate court to go digging? I mean, the law is, of course, that we're not required to dig at all. But sometimes you get, in these fact-laden cases like this, you get either an on-the-record ruling or you get a writing or both that are fairly conclusory, and you have to decide whether there's something in the record to connect. And if you read the written ruling and the on-the-record ruling, like there's not a lot of connection between the ultimate number and the evidence in the case. I mean, we presume that the court heard it, but someone might have to go back and read around in the testimony to find whether there's a basis for these income numbers or a basis for this 24-month duration. What's your answer to all that?
my answer to that is the court was very particular as to how she explained everything. Not only did she do all the relevant history and the facts that she determined, she went over the husband's income, averaging out the last 3 years, clearly explaining that husband had tax returns that say one thing, but his tax returns were commingled with his, not in a marital property sense, but commingled with his personal expenses. It was a business that grossed over $1 million a year, for the last 3 years. So the court was kind in terms of taking an average of those. And then the court looked at his reasonable expenses and determined that he clearly had $2,500 a month to pay toward her expenses. So that's from the ability to pay and also the financial resources. And there was no indication that his income was going to stop or they didn't make that kind of money. In fact, there were many indications that he had a lot more money than he was saying he did in terms of my client's needs. Again, she's 52 years old. It's a medium-range marriage, as we say marriages. There was no indication, but I think this is important, if you had an indication that she was trying not to get a job, right? Or she was making an active effort to not get work because the alimony situation was coming. That would be one thing. But that is not, of course, what happened. So the evidence was that there was an assault, cause of the breakup was in there to the extent that it was relevant, and the court was very clear to talk about what it was. When they broke up, there was a final assault that he was convicted of. There were grounds of cruelty of treatment. She worked for his company, not making a lot of money for quite some time. He got rid of her from that company, and she didn't have a job. Now, over that period of time, again, if there was evidence that oh my God, she was offered a job making $60,000, but she wasn't. Her father was sick. She was going back and forth from Virginia to Maryland, living with her daughter because she didn't have any money. As you can see, the money that they got from the sale of the home, except for $15,000, they couldn't agree upon. It was put in escrow. She didn't have access to that. So she was in a position where she, even at the time of trial, it had been 18 months, she was just kind of homeless and going back and forth. It was reasonable. And her living expense was $2,500. And it clearly said that he had the ability to pay $2,500. So that was the number that the court chose. And it was based on the financial needs of her and the expenses, and the ability to pay for him. So to say that there was no evidence to support the $2,500 is not factual. Now, 2 years. Why? It's interesting because there's kind of two kinds of rehabilitative alimonies as I'm thinking about this. There's the one where somebody's in their 30s or something like that, and they're going to go back to school, and they either put an expert, but they don't need to, and they say, I'm going back to community college to get my nursing degree, and within 3 years, that's when it'll be. So I need it for 36 months. But there's the other kind, which is interesting, which is this one, where she's 52 years old and she's kind of starting new. She's not going to go back to school and get a degree, nor is she required to, but to get herself back to where she can maybe save some money, get this extra $2,500 per month, maybe not even get a place initially, but put $5,000, $10,000 in the bank, or get some of the retroactive alimony money, which the court wanted for her to get lump sum so she could get back on her feet for 2 years, within 2 years. That kind of rehabilitative alimony, and it's interesting the way the court said it, get back to the single life, because they were together. She was relying on his income for the most part, and now she's out there on her own. So how long does it take? Like you said, it could have been 5 years, and that may have been appropriate as well. It could have been 1 year. And it's also interesting that the court considered that the defendant said he had some medical issues coming up. I think he had some surgeries coming up, so they delayed it for 6 months for his benefit to do that. So the court was considering all the factors of the case. So that's where, so $2,500 based on the evidence for 24 months, a reasonable projection, which is all the court's required to do. Could have been more, could have been less. Why wasn't it 23 months? Why wasn't it 25 months? Because it's 2 years. That's what we do. We often say with rehabilitative 3 to 5 years, and the court has within its discretion to do that. And it was absolutely based on the evidence. I think that the court recognized that she was the kind of person that was taking realtor classes, that was motivated, that would get back on her feet, that was healthy, and only gave her 2 years of rehabilitative alimony. And then, again, the retroactive to say, well, why give her retroactive? Why? Because she's still here? She hasn't, starved to death? No, he should have paid for those 24 months as well, and that lump sum that's going to come out of the house is going to help her also get back in. Perhaps if the court had not done retroactive alimony, it would have given 4 years. Perhaps if the court had given a monetary award out of the proceeds of the home, then it wouldn't have done the retroactive alimony. But this is the way the court fashioned it and thought it was the best way to do it. And there's no question that Judge Dumas put a lot of thought into it. And so there's no abuse of discretion. There's no clear error by any means. I think that's all I have, unless there's any questions. But this is, to me, it's completely within her discretion to do what she did, and it was completely supported by the evidence and the testimony. Okay,
right.
Thank you.
Thank you, Mr. Ruben. Mr. Kurtzman, you have 5 minutes.
I think Mr. Ruben's arguments points up the problem in the case is that no one can point to what evidence relates to the amount or the time of the award of alimony in this case. What different factors affected this award? There's nothing in the judge's decision that explains that for us. And that's what the court is required to do. And this case should just be sent back to the circuit court so that those findings can be set forth, and then it can be determined whether or not that's sufficient. Otherwise, it's just arbitrary authority without justification. And that's the problem. Yes, the court has the authority, But yes, the court has to explain so it can be reviewed. Otherwise, it's not law, it's just power. And the whole point of this is supposed to be what Aristotle said, law is reason without passion, I think. And so we have to be able to review, or the court has to be able to review what's happened so we can understand why it was done. That's the point of the whole process that we have here, why the court is required to make findings, so that we all understand what happened, why they arrived at these amounts, and then it's subject to review. But in this case, we don't know why. I mean, that's basically what it is. We have no idea why 24 months, why $2,500, because the court doesn't tell us. All we know from the court is that she's able to work now, and a diminished standard of living under the law is not sufficient grounds for an award of alimony. So I would just ask that the case be remanded back to the circuit court so it can make the findings that it needs to. Thank you.
Okay. Thanks you both. The case is submitted.